All right, let's talk about Articles 4 through 7. I'm going to be reading from the textbook. If you want to follow along, I'm on page 262 to 265. So Article 4, Relations Among the States. Section 1, State Acts and Records. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. So if we're looking at our notes, Article 4, Section 1 says states must recognize the official acts and records of other, and then what should go there is other states. I'm going to use a nice dark red today, I think. Basically, if you make a contract or if you have done something following the law of one state, another state can't punish you for that. Okay. Section 2, the rights of citizens. Clause 1, citizenship. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Number 2, extradition. A person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. And then Clause 3 talks about the Fugitive Slave Law. However, that part has been amended, and so I'm not going to read that part. So Section 2, the rights of citizens. Clause 1, all states must treat citizens of another state, should be the answer, the same. So it doesn't matter where you come from, your treatment should be the same as the citizens of that state. Clause 2 talks about if you've committed a crime and you've then run away, you're going to be returned to the state in which that crime was committed. Basically, the states are agreeing that they're all going to work together no matter what, and that someone who commits a crime is still going to be accountable, that someone who moves or travels to another state is still going to have their same protection of their rights. Okay, Section 3, new states. Clause 1, admission. New states may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, meaning we can create a new state, but it can't be within a state that already exists. Nor any state be formed by the junction of two or more states or parts of states without the consent of the legislatures of the states concerned, as well as of Congress. So if two states wanted to join together to become one big state, they'd have to have the approval of Congress. Clause 2, congressional authority. The Congress shall have power to dispose of and make all needful rules and regulations respecting the respecting the territory or other property belonging to the United States. And nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. So if there's land that's owned by the United States, then Congress gets to manage that land and make rules for it. Section 4 is the guarantees to the states. The United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion and on application of the legislature or of the executive when the legislature cannot be convened against domestic violence. What that's saying is that the states have a right to protection by the national government, whether there's an attack from outside of the country or there's a rebellion inside the country. All right, Article 5 goes on to talk about how the Constitution can be amended, and amended means changed. The Founding Fathers were smart enough to know that there was going to be, that they didn't know everything, and that there was going to be a need at some point to make changes to the Constitution. However, they purposely made that to be really difficult because they knew that the Constitution wouldn't be something that should be taken lightly. And so they make it difficult to change. There has to be a lot of agreement. It has to be very important to change the Constitution. So here's what the Constitution says. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which, in either case, shall be valid to all intents and purposes as part of this Constitution, when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by Congress, and that no state without its consent shall be deprived of its equal suffrage in the Senate. So they make it difficult. There's two options if you're going to propose a change to the Constitution. You can either have a 2/3 vote of both houses of Congress, or 2/3 of state legislatures can call for that national convention. And then in order to ratify that amendment, it gets even more difficult. You have to have 3/4 approval of either the state legislatures or 3/4 approval at a state convention. And so if we're looking at our notes, Congress can change the Constitution if they get a 2/3 majority vote in each house, and then it can ratify the Constitution if they get a 3/4 vote in the states of the United States. And so it starts with a 2/3 majority in Congress and then goes to a 3/4 vote in the states. Okay, all right. National supremacy, the supremacy of the national government. Section 1, Article 6, valid debts. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. So if there are debts or agreements that the Articles of Confederation government had entered into, they're agreeing to continue with those debts and obligations. Section 2, the supreme law. This Constitution and the laws of the United States shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges of every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. Okay, so what this is saying is that the Constitution is the ultimate law of the land. Which means that if there's ever a contradiction, if a state law or a national law goes against the Constitution is going to win every time. No state or national law, no state constitution can violate the national Constitution. And then Section 3, loyalty to the Constitution. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. And so in order to take your office, if you are being inaugurated as president or sworn into another public office, you have to take an oath of office. And in that oath, you say, I solemnly swear to uphold the Constitution of the United States. There is no religious test. You don't have to swear any loyalty in any particular religion, but you have to swear that you're going to uphold the Constitution. And then Article 7 explains how the Constitution can be ratified. Ratified means officially approved. So how is the Constitution going to then take effect? It says here, the ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. Done in convention by the unanimous consent of the states present, the 17th day of September in the year of our Lord, 1787, and of the independence of the United States of America, the 12th. In witness whereof, we have hereunto subscribed our names. And then all of the men who agreed with the Constitution at the Constitutional Convention signed the Constitution. However, on September 17th, when they sign that, they don't actually make it the law. It then goes to the states to ratify. And they write in the Constitution that they have to have 9 states, which is out of 13 a majority, have to ratify the Constitution in order for the Constitution to become valid and to become the law of the land. Fortunately, all 13 states eventually ratify, which means that there's a lot of acceptance and general consent that this is going to be the government of the United States. Thanks for listening.